All right, Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here today for oral argument in case number CV180261, Seidman v. Weiler. Counsel, each side has 20 minutes for your argument. The appellant can reserve time for rebuttal. If you decide to do so, please keep track yourself with the clock on the podium. The proceedings are being audio and video recorded, so if you would introduce yourself at the podium and your client, we would appreciate it. We have read the briefs and discussed the case. Please keep that in mind, and with that, you may proceed.
Thank you, Your Honor. My name is John Harris. I'm here for the appellants. The appellants are Lawrence Seidman, individually and as a trustee for an estate planning trust. In my process of arguing today, Your Honor, I'll break up the three defendants and the claims dealing with those. I'll start off with the claims against the defendants Weiler. The Weilers were the sellers in this real estate transaction, and Mr. Seidman was the purchaser. The standard for disclosure in a sale of real property was established in a case years ago called Hill versus Jones. And in that case, the trial court granted a summary judgment motion and indicated that the sellers had no affirmative duty to disclose past termite problems. The Court of Appeals reversed and indicated that where the seller of a home knows of facts that are materially affecting the value of the property, which are not readily observable and not known to the buyer, the seller is under a duty to disclosure, or I should say to disclose them to the buyer. The Court of Appeals remanded the case to the trial court. Contrary to what our trial judge said, I believe that the facts in this particular case are quite similar to the facts in the Seidman versus Weiler case in terms of the matters that were not disclosed and the knowledge that Mr. Seidman as the buyer had. Both parties, Seidman was buying a home from the Weilers. Hill was buying the Jones home. Seidman visited the home several times. So did Hill visit the Jones home. Seidman asked about the Weilers' home condition, and he had information that he was given in the real estate sale documentation. First, there was the multi-list, the MLS, and in the MLS, there was an indication that the roof was newer. The actual language in the MLS was that the home had newer AC units and a roof, which would lead to low maintenance for years to come.
What was the representation, counsel, in that termite case?
The representation was that
There were no termites.
the problem in the flooring was a water loss, was water damage, and the ripple that the buyer saw was not termites. So,
isn't that very different here? It's clear that there was a representation that there had been problems with the roof. There had been water leaks in the past. That seems very different from Hill.
well, what's different about it, Your Honor, is that, or I should say what's similar about it is, in my view, there are concealments to problems.
But do you have to go through and list every single spot on the roof? You say there have been leaks in the roof in the past, and you need to have an inspector look at it. If you want to have building contractor come and look at it, you can do that. Isn't that very different than how much disclosure do you have to give? If you said there have been problems with the roof in the past and you should have an inspector look at it, why isn't that enough?
It's not enough, Your Honor, because the truth was not provided. What was said was that it was a newer roof, and it was not a newer roof. It had really never been repaired, but the Weilers tried to document a repair 12 years before that. That was a lie. It was actually 18 years before that. So this whole thing about a newer roof, and the newer roof language was paired with newer air conditioning units. The air conditioning units were 5 years old. So the indication was pairing the air conditioning units 5 years old with a roof to make them both seem to be the same age.
So what, in your view, when would it have been acceptable to say a newer roof? It's newer than the original roof, but if the roof were 6 years old, then that would have been okay. 7 years old, 8 years old, at what point are you saying that you can't use the term newer roof?
Well, I think newer in terms of the air conditioning units was accurate because it was they were about 5 years old. Anything more than 5, 6, 7 years old, that's not newer.
Isn't newer a comparative term, counsel? Doesn't it derive its value from that which it is compared to? Newer, newish. It's not new, it's newer.
Well,
plain English.
The Weiler, Mr. Weiler testified in his deposition that the reason he used the word newer was because it was newer than an original roof. So we're talking about a 20-year roof that he's claiming to be newer. That's just not true.
So you're arguing about the qualitative meaning of newer, and that the understood definition should have been your client's understanding of 5 years rather than, I think, the definition of the word, which is if you have something that's 100 years old and something that's 99 years old, the thing that's 99 years old is newer than the thing that's 100 years old.
Your Honor, if that's the measuring stick,
No,
then we're lost. Then you can lie about anything you want in a home and get away with it. The question is, what does newer mean? Newer means what is the reasonable definition of newer in the purchase of a residence. And if I'm a buyer and I want to know if something is newer, I don't think that it's newer than the original roof that was put on. That is just grossly out of control.
Well,
if that's the standard. It's a lie.
You say it's a lie.
It is a lie.
But what about the context of providing for an inspection and to have an inspector look at it? Doesn't that turn kind of the descriptions, since it doesn't really matter, even if it's a 6-year-old roof or a 4-year-old roof, if it's in terrible condition, the newer part isn't what your client's interested in. He's interested in having a roof that doesn't leak. And
True.
So isn't that the purpose of having an inspector come and look at it to say, yeah, this roof is in good shape? Even if it's a 20-year-old roof, it can be in very good shape.
Well,
A 2-year-old roof can be in very poor shape. So why is newer it seems to me the seller acknowledged they probably shouldn't have used the term newer. I think I remember reading somewhere that he's agreed that, okay, maybe newer is not the best word to use, but I still have a hard time understanding why that's critical when newness as opposed to just the condition of the roof, and that's the whole point of having an inspector look at the roof.
Well, if you look at all the information that was provided, and that included the SPDS, which talked about the property having a roof that was repaired approximately 12 years before, that there were roof problems, but that had been corrected. There was
It disclosed roof leaks and repairs, correct?
Those kinds of things were disclosed, but they were untrue. They were not accurate. They were not true.
What was inaccurate about checking the box that said there have been historical leaks? What was inaccurate about that?
Nothing.
Okay. What was inaccurate about checking the box that said there have been past repairs?
Nothing.
Okay. So you're talking about what was written in, which is what? Not taken care of. What was it?
The part about newer air conditioning units and
No,
the
no,
roof.
I thought you were talking about the seller's
Seller property disclosure statement. There was language there that talked about how there had been repairs, leaks and repairs, that the repairs had been done 12 years before, when actually it was more than 18 years. There was also language that dealt with, it wasn't the repairs, but it had to do with some emails at March 22nd, 2013, where the home inspector said, I see a water stain on the ceiling of the garage. You should find out what that's about. And so Mr. Seidman did. He asked the realtors for the sellers what that was about. The sellers responded by saying that the leak in the ceiling in the garage was from a leak that happened in the past that had long since been repaired, and also that the home, or I should say the roof, had been resealed in December of 2012, which would have been 3 months before Mr. Seidman purchased in March of 2013. The point is that all of these allegations, or I should say all of these comments, were false.
Isn't it, at some point, doesn't your client say, I need an allowance, there are problems with the roof? And the seller says, okay, well, I'm not going to fix it. I'll give you $1,000 credit. So there's an acknowledgement that there are problems with the roof. Whether $1,000 is enough to fix it is obviously a negotiating point, but isn't the fact that there is an acknowledgement and there's an agreement, we're going to give you an allowance for that. Doesn't that suggest, okay, yeah, there are problems with the roof, you take care of it, I'm not going to do anything more, but if you want to buy the house, I'll take $1,000 off?
No, Your Honor, that's not what happened. Let me try to be clear. Because you'll hear that there was $1,000 given to avoid the sellers, or to keep the sellers from having to do any repairs. But what happened was this Benzer document was presented to the sellers and saying, we have these 8 or so items that need to be replaced or repaired. And they were minimal kinds of things. One that had to do with the roof had to do with doing some caulking of some flashing. It didn't have anything to do with leaks, because the Weilers had represented that the leaks had all been repaired. But just like in Hill versus Jones, they weren't repaired, and it wasn't water damage. In fact, it was termites. So what happened in the $1,000 alternative to for the sellers doing repairs was that there were minor items that were
but it
worth
included some repairs
$1,000
to the roof. Presumably those repairs are to keep a roof from leaking.
Yes, Your Honor, but that wasn't the problem that we're here battling with the Weilers about. We're not talking about roof leaks that caused that. We're talking about some caulking or some clean off of some debris that was on the roof, both of which the home inspector found. Unfortunately, the home inspector didn't find significant roof problems, which Mr. Seidman found when he did his repairs after buying the property.
The Benzer, the exchange, the negotiated exchange, is $1,000 for quote, credit or professional roofer to repair gap above the flat roof flashing in number of areas, 1. 2, credit to determine source of moisture, damage to base of master bathroom, cabinets near shower, and repair. Is that accurate? That's what the $1,000 was for?
There were 8 items, but those were 2. Yes, Your Honor.
All right. Those aren't roof.
The second one that you just read was not. That was a bathroom water leak issue under a counter. The first one was a roof-related matter, but it was putting caulking on the roof to reconnect some flashing. It had nothing to do with either the age of the roof, the leak content of the roof, and the problems that Mr. Seidman found after he purchased the property.
So Would you concede that newer isn't a definite term? It doesn't have a firm meaning? It's a variable term?
I think if you're being honest as a seller, which you're obligated to be, that you have to be reasonable in your use of the word newer. And if you want to say it's newer than an originally built roof in 1995, then sure,
It's
we can lie
fraud
about
if you
anything.
don't say that. If the house was built in 1950 and there's a new roof installed in 72, if you write newer, that's fraud. Is that what you're saying? That's a lie? That is fraud.
Well,
Calling that newer.
if you want to say the roof is newer than the original roof, then say it. Otherwise, you're giving
Fraud.
the impression to a buyer, to any buyer, that this is a newer roof. And what does a buyer want? He wants to buy a property that doesn't have any problems.
But
Or,
that
The
doesn't-
client ever asked how old the roof was.
well, it was in the seller's property disclosure statement. It said it was approximately 12 years old.
I thought that was when something was done.
There were in 1995, there was some actual repairs done to the roof by a licensed roofer.
Right. That wasn't the date of the roof. That was when they did something on the sun side. I didn't understand. It was shorthand.
Weren't there coatings that were put on the roof, though? Isn't that, it's a flat roof. You're not replacing the whole roof. You're recoating it or something?
Part of it is a flat roof, Your Honor. The other part is a tile-covered roof. So even what Mr. Weiler testified about in his deposition was that he hired landscapers and or laborers to put the white reflective paint coating on the roof, and he called that a reseal. That's not a reseal. That's another lie. There were lies throughout this whole process, and Mr. Seidman didn't know about that. And more importantly, let me add one more thing. His realtor didn't help him either. His realtor has a responsibility under R428-1101A and I to assist. Well, first, under A, she has a fiduciary duty. That's Anita Berg. She had a fiduciary duty to Mr. Seidman to protect him and to promote his interests.
Can I ask you a hypothetical here? Just that let's assume that the seller that there was a leak and the seller hires someone who comes in and says everything has been fixed. Is there now strict liability? He's hired the best roofing company in the valley. They've come in and fixed the roof, but it turns out there are still leaks in the roof. Is there strict liability when they said the roof there were leaks in the roof, it was fixed, I had a certification that it was fixed. Turns out they didn't do a very good job fixing it, and it still leaks.
Well,
Why isn't that the duty of the inspector to come in and find out that the roof's in good condition or not?
If the Weilers had brought in a licensed contractor to do the roof work, then they would have a warranty. They didn't have a warranty. They didn't have anything. They didn't produce any documentation whatsoever. They had a landscaper and they had a laborer go up and brush some reflective paint on the property. So if that were the case, Your Honor, the Seidmans would have recourse to the licensed roofing contractor because there'd be a warranty. That didn't happen here. I'd like to reserve the rest of my time, please.
Thank you, counsel.
May it please the court, my name is Tony Vitagliano. I represent Realty One defendants, Realty One. Appellees have agreed to split our time, so I'll use 7 minutes. So unless you have specific questions, I'd like to hit one, Seidman's Realty One reply brief's new agreements, arguments raised there for the first time, which the court should reject for not being presented in the opening brief and because not supported by the evidence, and Seidman's misstatement of the record cases and the law throughout. Contrary to the reply brief, the trial court was neither confused nor ignored R-428-1101, and the court's ruling was not procedural. Seidman alleges Realty One's duty was, quote, not limited to reasonableness, close quote, but was, quote, to assure that all material adverse information regarding the property was fully discovered and disclosed to plaintiffs in writing, close quote. Opening brief, page 49, and amended complaint, R80 at paragraph 13. That's contrary to Arizona law and policy. Quote, to require the agent to give the principal notice of any conceivable information might possibly influence the principal would create an oppressive burden on the agent, close quote, and be so, quote, burdensome as to be unreasonable, close quote. Musselman.
Counsel, I have a question for you.
Yes.
So we have two summary judgment phases here, right? We have your client's summary judgment and the agent's summary judgment. Is that correct?
Three. The two agents and the sellers.
Right, but it was in two bites.
Correct.
Okay. So I want to focus on that first bite. I believe you filed your motion for summary judgment on February 6th.
Your Honor, if you're addressing the first bite, I would reserve that for counsel for Weller's because we joined his motion. Ours was the second bite.
So who is that?
That would be.
Okay. Sorry,
all right.
go ahead.
Thank you. Thank you. So the court said in the 12-5-17 argument, page 4, 10 through 18, quote, now obviously there's sort of a standard of care that goes along with the breach of fiduciary duty and also with the negligence claim. And from everything I've read, it appears to me that it's correct, that it's reasonableness. So the way I view the breach of fiduciary duty is that the Realty One defendants had a duty to make reasonable efforts, etc., what's set forth in the Arizona Administrative Code and in the case law. The reply brief at pages 23-24 agrees that the scope of duty is a question for the court. The court then ruled as to Realty One there was a lack of causation and no legal basis for imposing the duties Seidman claimed to impose. So the court's ruling wasn't procedural. It ruled that Seidman didn't carry their burden on proof of scope of duty, breach, and causation. Moreover, the reply brief makes numerous arguments and allegations for the first time, which
Counsel, didn't Seidman produce an expert report? In fact, at the outset of the lawsuit, he said, under the statute you just cited, one would be needed. And then I think he produced 4 of them during the course of discovery, included them in 26.1. Why shouldn't we consider that?
Because he did not attach it as in his response to the summary judgment motion, indicating to us that he viewed it the same way as we did, that it doesn't provide the genuine issues of material fact to support his position. Had he attached it, then in our replies we'd have to respond to it. But he never referred to it. He never relied on it. He never attached it.
He says you never argued duty. Is that true or false?
Oh, no, Your Honor. Please take a look at the briefing. We argued duty, we argued causation, and if there's no duty, we argued no breach. So, yes, we argued all the elements of the claim, and some of the various little ones of the negligent misrep, they may have been scooped up and everything else, but clearly the major elements are argued in all the briefs by both agent defendants. The reason it's not addressed in our briefing is he didn't attach it. So we don't need to reply and argue that his affidavit's no good because it's not attached. And the court then did review it and had problems with it. And you know, I think our briefing handles all that, and I'll refer you to that. I want to hit some of these arguments that they made. I mean, they make an argument for the first time, not made in summary judgment before the court or in the opening brief, that Burge, quote, made affirmative decisions, close quote, quote, encouraged Seidman not to consult a licensed roofer, quote, breached her duty to Seidman by voluntarily exceeding her license scope and recommending against hiring a contractor, quote, Burge's recommendations that the roof was satisfactory and did not require a separate licensed roofing contractor to investigate the roof, quote. These are all new arguments, and the quoted allegations are raised for the first time and have no support in the testimony.
Was there an argument that your client encouraged him to engage an inspector and sign away any responsibility or liability on the part of the inspector for a deficient inspection?
No, Your Honor. There's an argument by the plaintiffs that because the inspector had a limitation of liability, that somehow that would rope us into we should have reviewed their contracts. Clearly, everything says, look, these are one of the people our people have used, and they're good. We make no representations as to whether you should use them. We make no representations as to the terms of their agreement. Every document says get attorneys to review legal documents. We're not attorneys. We don't do that. So while there's that allegation, it really doesn't play.
Standard provision in
I think, as in any agreement, you have to read it. If it's there, you negotiate to try it out, to get it out. And if it doesn't bother you, you leave it. I know I've had my home inspected. It's had that in there, and I figured, you know what? You're paying $400. What do you really expect here? And I went with it. So, I think it's open to everybody. If they want to negotiate it, they can. And if they don't like it, they can go to another inspector. As we did not tell them to use that inspector. Use whoever you want. Here's 5 that have been used that we have heard are good, but use whoever you want. And the testimony throughout says he knew that. He says, Seidman testified, quote, if the home inspector had said this is really questionable or whatever the technical terms were, then it would have necessitated the roof inspection. But that's not what he reported. I asked him questions face-to-face about the roof, and his response was that it was normal and there was no need. And he also argues that he knew full well that he could hire anyone he wanted to do anything he wanted if the need arose itself. But as I said, based on his review of the inspection report, he did not see the need.
Counsel, I have one question, because I know you have to do a tag team thing.
Yeah.
So we have your client prevails on summary judgment because duty is not addressed, and there's no expert report. But there was an expert report. It just wasn't exchanged or identified in the statement of facts or argued. And so is it fair to say that it's more of a procedural argument that it had been disclosed, but it was too late to consider? And if that's the case, why not supplement? Say, well, this was disclosed. What's the prejudice?
So no, Your Honor, it's not the same case. Obviously, the fact that it's disclosed, a lot of things, as you all know, is disclosed in discovery. Whether you use them or not is up to you strategically, whether you think it's going to help you or not. They may have decided strategically not to use it because there's holes every which way. As I point out in our brief, he hasn't reviewed all the documents. He's making these crazy statements as to duty that they're supposed to do everything. So his definition of duty doesn't fit the law. So his affidavit can be attacked, as my brief says, on many grounds. That's maybe why he didn't use it. To now claim, oh, wait a minute, you know what, here it is. I'm sorry, that's not how it works.
Well, that's not how it works. Expand on that. What is the prejudice? It had been disclosed. You had a chance to read it.
The prejudice was, Your Honor, we had no way to raise all these issues with it that we're doing now because he never attached it, never relied on it, and didn't use it in response to the brief. So we show up at oral argument, and all of a sudden, he wants to argue that. The judge found that was unfair, and the judge also found, in addition to what you said, Your Honor, the judge also found on causation. So it's not procedural. I mean, the judge says there's no evidence here to support the elements of your claim. Causation, duty, and if no duty, then breach. So it wasn't procedural. And the judge says, even if I take this one doesn't meet the requirements of Rule 80. It also has other issues. And so, Your Honor, it's not just procedural. And the fact that they chose not to use it doesn't give them the opportunity, as our briefs say, to come later and say, oh, by the way, here, let me give you that. The cases all say, no, you can't do that. And thank you, Your Honor. If you have more questions, I'd love to answer them, but I need to give up my time. Thank you.
Thank you. Thank you, Counsel.
May it please the Court. My name is Adam Buck, and I represent the appellee Frank and Anna Weiler. Now, the judge in this case based the decision primarily on the Hill v. Jones legal standard that's set forth. And it does say a seller has a duty to disclose known facts materially affecting the value of the property that are not readily observable and are not known to the buyer. So I just want to take a few minutes and talk about that last component, that are not known to the buyer. This is a big difference between the Hill case and our case, is that the roof leaks and the reverse grading and drainage issues were actually disclosed, whereas in the Hill case, they weren't. In the spuds, as you pointed out before, it says, are you aware of any water damage or water leaks on the property? And he checks yes. Some roof leaks. That doesn't seem to be an ambiguous statement. Yes, there were, and in fact, his own expert, his home inspector.
Well, Mr. Buck, what about the newer roof? You heard the discussion that we had with Appellant's counsel. What is your take on the, quote, newer AC unit and a roof?
So I would say, number one, newer is relative, so it can't be the basis of any type of fraud claim. But in connection with that disclosure, the MLS, there was the spuds that he got the same day because it was attached to the MLS. And it does talk about repairs that were made 12 years ago. So I don't know how a reasonable person could say, well, the roof is newer than 12 years when he said, hey, we made repairs 12 years ago. So I don't think it's a reasonable assumption that 5 years, the roof was 5 years old. But I think the critical component is it doesn't matter if it was new or old. The question is, did it leak or did it not leak? And did they disclose those past leaks? Because the seller's duty is to disclose. It's not to guarantee the work.
It doesn't matter. Well, your colleague says it matters.
That what matters?
Whether it's new or old.
Well, yes, I'm just saying that it doesn't. What he's saying is he thought it was 5 years old, and in his personal opinion, 5 years should be the definition of newer. I don't know that there's any legal standard. There's no case that says newer means 5 years. But it's not even a reasonable assumption under the circumstances when the spud said 12 years ago we did some roof repairs. So I just don't think that the newer versus older is really the issue in this case. I don't think the trial court viewed that as much of an issue.
Could I ask an unrelated question?
Yes.
Putting up new drywall, let's say the allegation is the seller just drywalled over some mold in the wall, and there's just new drywall now, an inspector wouldn't see it. Does that create a fact question that something else should have been disclosed? There was a repair, and they just drywalled right over the mold.
Well, the spud says that there were leaks and that they were corrected. And in his deposition, Mr. Weiler said the only reason he replaced that drywall and repainted was to fix the prior leaks. It's all connected with the leak issue. They're not different issues. So he already disclosed there was a leak, and by the way, we fixed it. And so they're saying he never disclosed that we fixed it. And we're saying, yeah, we did. It says there were past leaks, and we corrected those.
Is that apparent? I mean, is there any disconnect there between substantial mold growing in the walls and tearing that out, reconstructing that structure, and that being covered with the statement that, yes, there have been leaks and they've been taken care of? Does one capture the other?
Well, are you suggesting that Mr. Weiler completely remodeled?
I'm not suggesting anything. I'm saying
Okay.
you had said it was disclosed.
Right.
They said there was a leak. So I'm asking, is that disclosure, how far does that go if you take Judge Catani's hypothetical and you have mold growing through the walls and it's due to the leak, question, torn down, reconstructed, take that. Now the disclosure remains static. It means exactly what it is here. There were the leaks and they were repaired. Is that sufficient?
Yes, unless my client knew of the mold. So my client's job is to disclose what he knows. And there's no evidence that he knew of any mold. There's no evidence.
What if he knew of the mold?
If he knew of the mold, he would have to disclose that, and he would check the box that there's water damage, but he already did check that box. Are you aware of any water leaks? And he said yes.
Counsel, let me ask you a question. Your colleague took a deposition seemingly after the discovery deadline expired. What happened there? And then the judge, on one hand, said the record is closed, but you can continue to take discovery. I didn't understand that.
Well, if I remember correctly, we'd filed our motion for summary judgment, and I believe they asked for additional time, and the court gave them additional time, and they canceled. I guess I'm a little vague on how that happened, but it was after the fact, and then once they took it, then they said, we want to supplement the record with the deposition testimony. And I believe the trial court judge said, well, it really doesn't matter, because once you disclose there are water leaks, that's really the issue. And he said, well, then I fixed them, but he already said there are water leaks and I fixed them in the disclosure statement. So having somebody say, oh, yes, I did fix them, it doesn't really change the analysis at all. So I think it was fairly straightforward what the court was deciding, and it's essentially when you're a seller of property, if you disclose what you know, if you're honest and you check the right boxes, you should have some level of comfort that you're not going to get sued later.
And I don't want to leave your colleague out.
That's true. All right, then I will wrap it up and let Mr. Orcutt take over. Thank you.
May it please the court, Michael Orcutt on behalf of the RE/MAX defendants, which includes RE/MAX Excalibur, Kathy Laswick, and Michael and Maricruz Martinez. The RE/MAX defendants in this case were the listing agent and brokerage on behalf of the sellers. There's a case directly on point and controlling with respect to the alleged non-disclosure claims against a listing agent, such as RE/MAX in this case. That is the Aranki case that's cited in the briefing. A virtually identical fact pattern in Aranki, in which a buyer of real property sued a listing agent and brokerage, alleging that the listing agent failed to disclose latent or material defects. The listing agent brokerage moved for summary judgment, as in this case, and the listing agent prevailed, and the court's holding was that the buyer of real property must come forward with evidence, admissible evidence, tending to prove that the listing agent had knowledge of but failed to disclose a material defect. And that is exactly on fours with the case before us. There's absolutely no evidence in this case that the RE/MAX defendants had knowledge of any undisclosed defect. So with respect to the non-disclosure allegations, Aranki is controlling. The second issue I'd like to briefly address are the statements in the MLS, which is the multiple listing service document. At one point I don't believe has been addressed today is the lack of reliance on that document. So the MLS is a document that's not readily accessible to the public. It is a document that's only available to realtors, and it is basically a marketing piece. In this case, during his deposition, Mr. Seidman was asked whether he could recall receiving that MLS document as part of the transaction. He testified that no, he could not. And that was significant to Judge Bergen. And in fact, in the transcript at oral argument, she recognized that Mr. Seidman had not come forward with evidence that he relied on the representations within that specific document, and instead, Mr. Seidman's testimony was that he relied on other sources of information. He had a specific conversation with the Weilers about the roof. He testified that the home inspector provided, obviously, an inspection report that covered the roof. But Mr. Seidman also testified that he had discussions with the home inspector about the roof and even went on the roof and made comments about some sort of a sponginess with the roof. So in this case, there wasn't evidence that Mr. Seidman relied on the MLS statement. Equally compelling, and this was another basis for summary judgment, Your Honors, was that the statements in the MLS are puffery. This, again, was a marketing piece. It has long been the law in Arizona that expressions of opinion, and even exaggerated opinion, are not actionable in a marketing material. These are classic examples of puffery. The house was beautifully remodeled, lovingly maintained, and the roof should provide low maintenance for years to come. These are not objective statements. They're subjective, and they're simply puffing under Arizona law, and they're not actionable.
If you could wrap up, counsel, I think you're...
I can. That's if Your Honors have any questions, I'd be happy to address them.
I don't want to wrap up if you'd like. I just wanted to...
No, that's sufficient, Judge. I think our position is well set forth in the briefing, but certainly if Your Honors have any questions, I'd be happy to address them.
Thank you, counsel.
Thank you.
Your Honor, let me hit some of the highlights here.
Can I ask just one question before you start? And that's,
Yes, Your Honor.
what in your view is the most compelling evidence of fraud?
It would be the non-disclosure of not only the water leaks, the roof leaks in the house, but also the mold that was present in between the two bedrooms, which was covered up.
Was there evidence that the seller knew about the mold and didn't disclose it? You're saying the evidence is just that there was mold and it wasn't disclosed?
It's not realistic, in my opinion, for a reasonable person to hire somebody, in this case his ex-son-in-law, to do repairs on the property and not know what happened. That means he knows that there was water leaks in the ceiling, there was drywall that was cut out, there was drywall that was placed on the underside of the patio. The Weilers, it's just not palatable, logical for the Weilers, having lived in this home for 20 some odd years, to say they didn't know anything about it. And frankly, it's insulting.
That's the evidence that they've lived there for a long time.
Yes. 27 years.
They must know.
Absolutely.
And that's enough to get past summary judgment.
Well, if it's there and they did the repairs, they're going to pay.
Well, that's something else.
They're going to pay for what happened, so they would have known what happened. It's unrealistic to say they had repairs done but didn't know what the repairs were.
Right.
I mean,
you seem to be saying two different things. You have this, they lived there for a long time as an independent, freestanding piece of evidence. And that's what I'm asking about. You think that is material evidence to get past summary judgment?
Absolutely. Just a few quick items. None of the defendant realtors ever denied that there was a duty, and that's why the arguments dealt primarily with the provisions of R428 1101A and I. And frankly, even as counsel argued a moment ago, the defendants never brought up the issue of the expert report. In fact, it was the judge that brought that up, and they gladly just glommed onto it. And then one more thing about Hill. The Hill buyers did not know that there was a problem with the flooring. They saw some rippling in the wood flooring, and they asked the seller if that flooring was termites. And the response was, no, it's water damage. Same thing here. Mr. Seidman had indications, whether it was through disclosures or not, and he asked about it, and he was told everything is fine, there are no problems, and wasn't the case. Thank you.
Thank you, counsel. Thank you both, all four of you, for your argument. We'll have a decision in the ordinary course. We are adjourned.